this issue is about the nature of the judicial power under our American system of constitutional government. Yes, excellent. Thank you, Louis, for bringing up the related documents. And words are just appearing in my mind now. I love these conferences. I get inspirations when I'm under pressure like this. The bigger picture is that, and I've said it before, but it just kind of sounds like warm and fuzzy ambiguities, but the cold hard fact is that the closer you get to the grassroots, the greater the physical world empowerment really is. This is why our town constables at the 10 household community levels, they are the ultimate people with the ultimate guns in their local township communities, and they've got the authority to point those guns at anybody that they decide to and bring them into their local court of law or any other court of law that's appropriate. So long as they're acting in good faith, they have the right to do that. And my focus here is just on demonstrating that if you can think in your mind of a sphere, like an egg, the intellectual, metaphysical mumbo-jumbo is all dealt with in the center. It's soft, it's pliable, lots of communication going on. But the people that administer the force, like the eggshell, it's on the outside. That's where the hard, tangible resistance to the outside world, the lawless people, really happens. Is through our town constables, and they're through their deputy constable peace officers, which are each of the qualified electors, basically. And here under, right above the town constables, is the 100 courts at the precinct level. And that's what I'd like to focus on here, because this is where the phrase original and exclusive jurisdiction comes from. And lots of courts, including the U.S. Supreme Court, claim original jurisdiction, and I think to some extent they also claim exclusive. But these are common law terms, and the Constitution document of the federal government, as well as all of the state court Constitution documents, they are municipal charters in their essential nature. They created a private corporation for a public purpose that's a municipal private corporation here to serve a public purpose. It's not an assembly of the constituents like the Supreme Court of the precinct, the 100 court. They have real common law jurisdiction, exclusive jurisdiction to form their jury and to try the case there, if that's where the breach of the peace is alleged to have occurred. Okay? And the county court and the state level Supreme Court and the federal Supreme Court and all of the other courts at the higher levels above the precinct, they are only there to be drawn into play if there is demonstrated clearly some problem with the manner in which the precinct court that was in charge of the original case adjudicated the matter. And so remember, like the egg, everything's on the outside, right above the ability to administer force with guns through the town constables at the township level. The next step up, the judicial original and exclusive jurisdiction, where the 100-man army, like a Roman centurion described in the Bible, has the authority to go anywhere and tell anybody what to do, so long as it's related to a case before the court. That is where this rubber really meets the road. And this is affirmed basically in the 6th and the 7th Amendment to the U.S. Constitution. I don't like the U.S. Constitution document basically, but the Bill of Rights contains all kinds of pearls of wisdom and empowerment that empower us in the 6th and 7th Amendment, work with the 7th Amendment and the 1st Amendment and all the other amendments really, really well. And so we can win this battle. The law's on our side. We've got the moral high ground. We've got the legal high ground, lawful high ground. And here under, I would like to go ahead and jump into agenda item 3, where we're discussing the profound powers of the precinct-level judicial officers, as we're describing it in our Organizing Self-Governing Communities document, from the bottom of page 9 through the center of page 10. Yes, thank you for pulling that up precisely, Lewis. Hereunder, a few citations to some state statutes will clearly show how this all-important judicial power has been profoundly decentralized, right on down to the precinct levels of local government. And here we're citing some Oregon statutes. Oregon statutes clearly recognize this at ORS 1.270, wherein is clearly referenced that every other judicial officer, excluding the municipal jurisdiction ones, may be chosen from the precinct level of politically subdivided county jurisdiction. That Oregon statute clearly references the precinct, choosing their judicial officers. And Michael, I think we've had specific conversation about tangible, real-world empowerment of these precincts and these local judicial officers. This is one citation from Oregon statutes that specifically references this kind of power being in the precincts, and even to cover an issue that is again mentioned later in this section of the outline, even though we're citing Oregon statutes, every state except Louisiana has embraced common law as general public law that's to be applied in a de jure capacity as opposed to the de factos that Lewis is concerned about. De jure organic public law of the people is based on common law. And every state in the Union has formally embraced this as general policy, except the state of Louisiana, which is under the authority of, has formally embraced Roman Empire municipal administrative law. But continuing on, the Oregon statutes here referenced merely articulate correctly, I believe, general common law principles, and thereunder, even if you can't find similar statutes in your state when you're trying to pursue this line of thought and grassroots empowerment for your community, you can cite the Oregon statute as an authority of correct application of principles of common law in your state. And also, even if you don't have statutes as powerfully worded as the Oregon statutes, frequently case law related to those issues will provide you some type of color of legitimacy for advancing these kind of arguments in a plausible manner against entrenched de factos. But moving forward with these statutes past the issue that this is at the precinct, at the grassroots decentralized level, like an egg with the stability, the force, the supreme peacekeeping authority for the judicial power at that grassroots precinct level. Moving on to exactly what kind of power that these courts of justice, they're referred to in Oregon statutes, that phraseology is harmonious with the court of law, like we are, because justice is the supreme law, and all real law promotes justice. It's just that simple. It's an organic process at these higher levels where we're bound by principles. And so Oregon statute particularly 1.010 and subsection 4 elaborates clearly by recognizing that the courts of justice over which these precinct-level judicial officers preside have lawful authority to compel obedience to its judgments, orders, and process, and to the orders of a judge out of court in a suit or proceeding pending therein. Thank you, Lewis. So the judge by himself has power. There's other Oregon statutes that refer to the difference between a judge and a court. That's real valuable surgical precision because, yeah, well, anyway, I won't get distracted on that. But that's a real good embodiment of ORS, this powerful statute, ORS 1.010, subsection 4. Continuing on to summarize subsection 5, continues to clearly recognize that this power extends to control in the furtherance of justice, the conduct of all other persons in any manner connected with a judicial proceeding before it, in every matter appertaining thereto. That wording is extremely empowering.